Hi friends, I am Vivek Dubey, Assistant Professor, School of Law, Dr. Hari Singh Gaur Vishwavidyalay, Sagar, Madhya Pradesh. Today's topic of our discussion and learning is all about Indian Evidence Act 1872, Part 2. Module 1st, Introduction, Module 2nd, Evidence and Rules of Relevancy in brief. Module 1st, Introduction. The first question is, why to study the Indian Evidence Act? Evidence refers to anything that is necessary to prove a certain fact. Thus, evidence is a means of proof. Facts have to be proved before the relevant laws and its provisions can be applied. It is evidence that leads to authentication of facts and in the process helps in rationalizing an opinion of the judicial authorities. Friends, further, the law of evidence helps prevent long drawn inquiries and prevents admission of excess evidence than needed. That is why, friends, we need to know why we need to study the evidence. Now, the next question, friends, is what is Indian Evidence Act? How does it function? To answer this question, one need to know how law proceed or propose to decide a case. There are two fundamental principles of trial in all the judicial systems. Firstly, it must ensure that parties to the case are given full opportunity to prove their case. And secondly, every dispute must come to an end. These two rules, which are juxtaposed to each other, must be balanced, and this is done by the blending of procedural law and rules of evidence. Now friends, a very important question is, what is evidence? The functions of court of justice are twofold: to ascertain the existence or non-existence of certain facts, and second, to apply the substantive law to the ascertained facts and to decide the rights and liabilities of the parties. For this, the court has to collect, peruse, analyze and shift the evidential material brought before it. The means whereby the court informs itself of the existence of these facts is called evidence. In other words, the object of every judicial investigation is the enforcement of a right or liability that depends on certain facts. The law of evidence can be called the system of rules whereby the questions of fact in a particular case can be ascertained. It is basically a procedural law, but it has shades of substantive law. For example, the law of estoppel can defeat a man's right. Law of evidence is one of the fundamental subjects of law, and therefore we must study it in detail and depth. The term evidence owes its origin to the Latin term evident or evidere, that means to show clearly, to discover, to ascertain or to prove. In the Indian Evidence Act, the word evidence is used in the sense of means. Now friends, section 3 of the Indian Evidence Act reads and defines evidence. It means and includes all statements which the court permits or required to be made before it by witnesses in relation to matters of facts under inquiry. Such statements are called oral evidence, and secondly, all documents produced for the inspection of the court are called documentary evidence. This interpretation is not exhaustive. It did not cover material objects like photos, weapon used in murder, blood-stained clothes which are admitted in practice. Court need not concern itself with the method by which evidence is obtained. Now, in a case Puspa Devi M. Jatia versus M. L. Wadhwani, it was held by the court that tape recorded conversation is a documentary evidence. In other case, Rama Reddy versus V. V. Gri, dog tracking evidence is held to be scientific evidence. In Abdul versus State, also the same thing is reiterated by the court. Now friends, we are going to discuss the types of evidence. The first kind of evidence is direct evidence, the second is circumstantial evidence, third is hearsay evidence, fourth is documentary evidence, fifth is oral evidence, sixth is scientific evidence, seventh is real evidence, and eighth is digital evidence. Now friends, the law related to evidence and proof is nothing but rules that must be observed in particular situations. Before certain forums, if the other party in a legal proceeding admits guilt, all is well. The other party can also deny the allegations in the plaint, and the existence of certain facts may be called into question. Then the parties or their witnesses have to give evidence in the court of law, so that the court may decide whether the facts exist or not. Interpretation of agreed facts is a rarity, and in most cases the existence or non-existence of facts has to be shown, and therefore the law of evidence plays a very important role. For example, X has entered into a contract with Y to sell his house for an amount of 10,000 rupees. In case of breach of contract by either X or Y, a court of law cannot decide the rights and liabilities unless the existence of such a contract is proved. Now, the friends, next feature is the law of evidence is the Lex Fori law. Why it is called a Lex Fori law? Because law of evidence is part of the law of procedure. That is why it is called the Lex Fori or the law of the court or forum. It means that Indian courts know and apply only the Indian law of evidence. Thus, the competency of a witness, whether a fact is proved or not, is determined by the law of the country where the question arose, where the remedy is sought to be enforced, and where the court sits to enforce it. For example, if a legal proceeding is going on in Sri Lanka and evidence is taken in India for the said proceeding, whether by commission or by assistance of courts in India, the law which will be applied during such recording of evidence will be Sri Lankan law of evidence. The next feature is the law of evidence is the same in civil and criminal proceedings both. A civil case of will and murder will have the same law of evidence. For example, the date of death has to be clarified or confirmed for the will to come into existence, and a murder date has to be set for proceeding further with the criminal investigations. 2. There are, however, certain sections that apply exclusively to civil matters and others that apply exclusively to criminal cases. In civil cases, mere preponderance of evidence may be enough, but in criminal cases, the prosecution must prove its case beyond reasonable doubt and leave the other alternatives presented very unlikely and highly suspect. So, the friends, degree of proof is strict in criminal cases and it should be beyond reasonable doubt. Friends, now the next topic is basic principles of evidence. The Act deals with relevancy of facts, mode of proof, and production and effect of evidence. The following principles are called the basic principles and the exceptions to the above principles. The exact application has been set out very clearly in the Act. First, evidence must be confined to the matter in issue. This is the cardinal principle of evidence law. Second, hearsay evidence must not be admitted. And third, the best evidence must be given in all cases. All facts having rational probative value are admissible in evidence unless excluded by a positive rule of paramount importance. Friends, now we are over with the topic of Introduction to the Indian Evidence Act. Friends, module 2, rules of relevancy and admissibility. Relevant evidence is evidence that makes a fact more or less likely to be true than it would be without the evidence. Looking for probative value. Friends, relevant evidence may be excluded for unfair, prejudice, confusion or waste of time. Relevant evidence is generally admissible and irrelevant evidence is never admissible. Two leading principles on relevance. First, that nothing is to be received which is not logically probative of some matter requiring to be proved. And second, that everything which is thus probative should come in unless a clear ground of policy or law excludes it. Relevancy exists as a relation between an item of evidence and a proposition sought to be proved. In an American case of Knapp versus State, the rule of law stated by the court was that the determination of the relevancy of a particular item of evidence rests on whether proof of that evidence would reasonably tend to help resolve the primary issue at trial. Now friends, another important feature is logical relevance versus legal relevance. Now friends, a very important fact which I want to introduce to you is that the Indian Evidence Act is more what concerned towards a legal relevancy than a logical relevancy. But we can see while reading it between the sections that the legal relevancy has a logical relevancy also together with it. But since most of the populace of the country was at that time illiterate, so the drafters of the Indian Evidence Act, Professor James Stephen, has made it a point of legal relevance. Now friends, a reality which is sensibly applicable may not be lawfully pertinent under the procurements of the Evidence Act, thus might be forbidden in proof. All allowable confirmation is pertinent, yet all applicable proof is not so much permissible. All certainties which are permitted by the procurements of the Evidence Act to be demonstrated are important, be that as it may, however pertinent, a certainty may be unless it is permitted to be demonstrated by the procurements of the Evidence Act. It is not allowable. A fact is said to be logically relevant to another when it bears such a causal relation with the other as to render probable the existence or non-existence of the latter. As stated above, all facts which are logically relevant are not legally relevant. One fact is said to be legally relevant to another only when one is connected with the other in any of the ways referred to in section 5 to 55 of the Evidence Act. And therefore friends, why I had said earlier that in the Indian Evidence Act we have legal relevancy and not logical relevancy. Now friends, logical relevancy is wider than legal relevancy. Every fact which is legally relevant is logically relevant, but every fact which is logically relevant is not necessarily legally relevant. Thus, a confession made to a police officer may appear to be logically relevant, but such a confession is not legally relevant. For example, section 25 of the Indian Evidence Act declares that it cannot be used as evidence against the person making it, the confession. Now, the Indian Evidence Act lays down in section 5 to 55 what facts are relevant, but the mere fact of logical relevancy does not ensure the admissibility of a fact very often. Public considerations of fairness and the practical necessity for reaching speedy decisions necessarily cause the rejection of much of the evidence which may be logically relevant. Thus, all evidence that is admissible is relevant, but all that is relevant is not necessarily admissible. Now friends, admissibility and relevancy are two different distinct terms, though may appear to be interchangeable, but they are distinct and they are of different meaning, which you had understood from this part of the lecture. Now friends, relevancy is the genus of which admissibility is a species. Thus, oral statements which are hearsay may be relevant, but not being direct evidence are not admissible. Legal relevancy is for the most part based upon logical relevancy, but it is not correct to say that all that is logically relevant is necessarily legally relevant and vice versa. Certain classes of facts which in ordinary life are relied upon as logically relevant are rejected by law as legally irrelevant. Cases of exclusion of logically relevant facts by positive rules of law are: first, exclusion of oral by documentary evidence, section 91 to 99 of the Evidence Act. Second, exclusion of evidence of facts by estoppel, sections 115 to 117 of the Evidence Act. Third, exclusion of privileged communications such as confidential communications with a legal advisor, communication during marriage official communications, etc. sections 121 to 130 of the Evidence Act. Now friends, we are going to discuss admissibility of the evidence. Friends, admissibility means that the facts which are relevant are only admissible by the court. Now, according to section 136 of the Indian Evidence Act 1872, the final discretion on the admissibility of evidence lies with the judge. Section 136 states that when either party proposes to give evidence of any fact, the judge may ask the party proposing to give the evidence in what manner the alleged fact, if proved, would be relevant, and the judge shall admit the evidence if he thinks that the fact, if proved, would be relevant and not otherwise. If the fact proposed to be proved is one of which evidence is admissible only upon proof of some other fact, such last mentioned fact must be proved before evidence is given of the fact first mentioned, unless the party undertakes to give proof of such fact and the court is satisfied with such undertaking. If the relevancy of one alleged fact depends upon another alleged fact being first proved, the judge may in his discretion either permit evidence of the first fact to be given before the second fact is proved, or require evidence to be given of the second fact before evidence is given of the first fact. The essential ingredients of the above section are: it is the judge who decides the questions of relevancy and admissibility. When a party proposes to adduce evidence of any fact, the judge may ask the party to clarify in what manner the fact would be relevant. The judge would admit the particular adduced fact only if he is satisfied with the answer of the party that it is indeed relevant under one or the other provisions of section 6 to 55 of the Evidence Act. Thus, the consideration of relevancy comes first and of admissibility later, and the judge will admit the fact only if it is relevant. In a recent case of Ram Bihari Yadav versus State of Bihar, the Supreme Court of India observed that more often the expressions relevancy and admissibility are used synonymous, but their legal implications are distinct and different from more often than not facts which are relevant are not admissible, and so also facts which are admissible may not be relevant. For example, friends, questions permitted to put in cross-examination, to test the veracity or impeach the credit of witnesses, though not relevant, are admissible. The probative value of the evidence is the weight to be given to it, which has to be judged having regards to the facts and circumstances of each case.